Okay, so let's get started. As both Commissioner Pavlak and Commissioner Rogers stated, we are looking for a really big year, and there's various reasons. And this is why, in anticipation of that, we started a month earlier. So here's a few things. I mean, for those of you who've been here before, this agenda looks quite familiar. Just seems like we're here maybe a couple of months ago, and now we're back again. So in terms of highlights, there are no major rule changes for 2019, but there are some changes, and we will highlight them. There are certain things that we'd like to emphasize and want to give examples in terms of how to make your life as well as the lives of board employees better. Now, for the 2018 session, and as I stood before you all 11 months ago, we did anticipate a record number of filings, and it did happen. In comparison to the 2015 reassessment, we were up about 34%. We adjudicated over 245,000 complaints and 540,000 pins. Now, let me put that in perspective. There are 1.8 million parcels in Cook County, and last year alone, we adjudicated 540,000. Now, a copy of the presentation will be posted on the board within 24 hours after the conclusion of this meeting. So there's a couple of things I want to talk about. One being the data compilation subscription service, board review rules. Now, for this year, as I stated last year, the digital historical summary form is now mandatory. We are doing away with the paper commercial summary form. That no longer will be accepted here at the board. Now, many of you have subscribed to the data subscription service. Is that correct? And we've received a great deal of positive feedback in regards to the data subscription service. And what we're hearing is that it really made your life easier. And these are just some screenshots in regards to the data subscription service and what it does. Now, what we're doing is we're reviewing the filing information to include the 2018 session, and we'll drop the 2015 session to readjust the tiers. And we may also readjust the fee structure as well based on the tiers. And again, these are just some of the highlights that we mentioned in terms of the benefits of the data subscription service, in terms of one-click access, improve efficiencies, automation on your side, and help to improve client relationships as you look through the files to determine which files you wanted to re-review and which files you didn't. Now, I had mentioned earlier that there are no major rule changes. However, I'd like to highlight one of the rule changes for Board Rule 3. If there are repeated violations of the rules, the law firm could be subject to suspension. You can suspend your rights to file at the board for repeated violations. Board Rule 14, and this is going back to the historical summary form. That form is mandatory. So we included that in Board Rule 14. Also, if you look at the rules, there were a number of references to hard copy, paper, and this is year 5 with DAPS. So any reference to anything for written, hard copy, paper, those have been deleted from the board rules. In regards to DAPS improvements, they there haven't been anything major in terms of what the user would experience in terms of DAPS improvements. Oral hearings, it's pretty much the same. However, I want to highlight, and this is something, the feedback that we've gotten from scheduling. Once you receive your hearing date, if there's a conflict, please immediately contact Ms. Rodriguez. You have to do that. It's a very complicated process in terms of the scheduling, and so when you have a conflict, please immediately contact her. The times now, who knows with the volume, we may have 8:30 hearings, I hope not. But who knows? Same time, 10:31 and 3. You've all seen this before, so I won't bore you with the details. Now, I want to emphasize the whole limit to the oral hearing request. The limit is 10. If there's an exception to be made, you have to immediately contact the schedule, Ms. Rodriguez. Okay, so now I just want to go through some do's and don'ts, and this is just some comments that we've received from analysts. This is from the front line. You must use the 2019 attorney authorization form. It has to be the board's form. Ideally, it will be executed by both parties, being the law firm and the taxpayer. And this goes back to in terms of the limit of 10 hearings per call. And the historical summary form is now mandatory. And I know this seems somewhat repetitive, but we want to make the point. Here's an example of the historical summary form that you've seen. Now, I just want to have a disclaimer. We've used examples and we've redacted the names, addresses, and pins, but we just want to show you some of the things just to drive the point home. Now, this was the old form that's no longer in use, and you see here, it was handwritten, it was somewhat difficult to read. By using the historical summary form, that pretty much addresses that issue, but the biggest thing with the historical summary form, it stores the historical income expense data and the assessment data, and then it updates each year. This is also something that's very important in terms to your pleading, particularly your brief or your petition. And there's just, I would say, some basic things that we would like to see as an analyst. Describe the property, the PIN, the address, the street address, the age, the size of the parcel, the land to building ratio. Provide historical assessment data, and preferably in units of comparison, be it square footage, stalls, or anything of that nature. You must disclose blended levels of assessment. Don't leave it to the analyst to figure it out. And then at the end, what's the basis of your request? Overassessment, is it based on sales? Is it an appraisal? Is it income and expense data? With the income and expense arguments, clearly identify where you derive your PGI, what's your cap rate, and why. And these are just some examples of quote-unquote narrative briefs. This is a point that can help, I think, everyone in this room in terms of Board Rule 27 and the grounds for a re-review. Is it newly discovered or obtained evidence? Was there a mathematical mistake? Did the analyst request certain data and you're responding to it? It can't be, please look at my appraisal again. That argument, we see it quite often, and to be frank with everyone, it decreases the efficiency for board's operations because we're looking at something that we've already looked at before. So your basis of the review can't be, please look at my appraisal that we've already reviewed. Here's just an example where we looked at the appraisal, we granted relief, and then the re-review was, well, please grant me more relief on the appraisal that you've already considered. In terms when you're uploading your documents, it's very important that you properly identify the documents. And one of the most important documents is the attorney authorization form. DAPS is keyword driven. And so if it does not hit upon the keyword attorney authorization form, even though it may be included with the attorney brief or something like that, you will receive a no change 7. So it's very important that you properly label your documents during the upload process. And the most important one would be the attorney authorization form. It can't be identified or tagged as attorney brief or anything like that. You'll receive a no change 7. And the reason being, it's an automated process. Now, we have seen filings where all the documents are tagged as other evidence and it's labeled and indexed in a PDF. It's really a matter of preference for some analysts, whether or not they like it. I've heard both sides. Some analysts hate it, some analysts love it. But again, in terms of being able to refer back to historical docs, say for instance, I was looking for the income and expense data for 2016. Well, it's not going to come up under board of the evidence. So it's just in terms of being able to reference back to historical documents. This is another key point that we like to make in regards to administrative no changes. You have the ability through the portal to request that up front. Instead of, sending us a letter saying that you're requesting the administrative no change. That puts a file unnecessarily in workflow that has to go through 3 different cuts. And the only request is the administrative no change. So you can do that through the portal. And we would strongly recommend that you take advantage of that. And these are just some different scenarios that would be, I think, ideal for an administrative no change, whereas you represented the taxpayer in the previous year, and this is the current tribe. Same appraisal that the board has considered in years past. You have an income argument, but pretty much the income is stable. There are no material changes. And these are just examples of where we granted relief in 16, and then they filed another complaint in 17, same appraisal. The board relief did hold, same thing in 18. Again, this goes back to keywords with appraisals. Make sure you properly tag it as an appraisal, and we would prefer the PDF and a color copy. And this is just a brief review of Board Rule 21 in terms of income and expense data. I think you all are pretty familiar with that. Now, one issue that we have at times is attorney-prepared rent rolls. We would prefer rent rolls that are maintained in the ordinary course of business of the taxpayer and not summaries prepared by the attorneys. I know there's certain circumstances where maybe the taxpayer hand writes the rent roll or something like that, or writes it on the back of a napkin or something of that nature. I get that, but if that's the case, explain it to us. And this is just going back to Board Rules 21 and 22 for vacancy arguments. We need time-stamped dated photos, interior photos of the vacant units. We also need documentation of efforts to mitigate the vacancy, be it broker listings, asking rates, things of that nature. Now, in the instance of a property that's been vacant for 20 years, now the question is whether or not applying an ox factor to the improvement is an accurate representation of the as-is value of the property. And so that's, in a case like that, you know, if it's been vacant 20 years, that's the highest and best use of that property. So we're looking for, I would say, appraisals just to establish the as-is value of the property. And this is, because vacancy relief is supposed to be, was intended to be temporary and not to last 2 decades. Now, with the vacancy affidavits, and this is just one example that we like to use. Say, for instance, the property was a West Chicago property, something that we had in the last group, but the vacancy affidavit that we received is dated in, say, July of 2018. Now we're in February of 2019, and so the question is whether or not that vacancy affidavit reflects the state condition of the property till the end of the year. Because, you know, you see here, the affidavit pretty much stopped in August. So what happened after August? So we really need an up-to-date vacancy affidavit. And this is just basically, in terms of Board Rule 19, most disclosed recent sales. And also submit the documentation of other recent sales. Now, this is something that we've talked about for a few years in regards to valuation of mixed-use residential properties, be it the 212s and the 211s. And what we have found is that oftentimes just a straight income approach does not appear to be the most reliable indication of value. And because of that, we've decided to place less weight on the income approach for the 211s and 212s, but also while considering, and okay, I guess it's the end. But also, we'll also consider uniformity in sales. Because, you know, when you're looking at a 212, and say there are a number of 212s in the same block, and one is income, one is only occupied, and you're looking at sales, and say sales for the 212s on that block are between, say, 700,000 to $1 million, but then you work one that's right next door on an income approach, and now you're saying it's worth 250. Something's wrong there. Something's wrong there. So really, even if you consider the income approach, you also have to balance the uniformity in sales if available. Now, this is a hot topic in regards to this evaluation of condos and co-ops and what weight will be given to what used to be termed the personal property deduction, and as of late, we would call it a market adjustment. And so, one of the things that we looked at is that, for one, you rarely see, if ever, any type of market adjustments or personal property deductions in appraisals. PTAB does not acknowledge it. In 1979, Illinois abolished a personal property tax. And so we just want to, there are instances where you may make adjustments to the comps relative to the subject. But to just apply a blanket adjustment to any and every condo or co-op workup, we didn't think that was, I would say, a reliable indication of value. And it's just a copy in the event that there was personal property involved, we have PTAC 203 form. These are just some, I think, practice tips that we mentioned last year in regards to evaluation of condos. If there's a complaint for the common area, that should be a separate complaint from the building. With 599, if there are recent sales within the subject, please disclose. Hearings, we mentioned that. The biggest thing about hearings, though, is to become prepared, know your case. With the commercial hearings, we prep those, so we've looked at those for quite some time. It usually takes, I would say, 8 to 10 hours for each day of hearing. So we know your case in and out, but we should know your case better than you. There are certain complaints that still must be filed with the counter. They'd be omitted assessments, exemptions, and the undervow. We always like to emphasize this in terms of unauthorized practice of law. We will report those to ARDC. Now, here we are. July 1st, we open for the 2019 session, and you see the towns listed: Riverside, River Forest, Rogers Park, Berwyn, Oak Park, Evanston, and Norwood Park.